Good morning. We're calling our meeting to order. This meeting of the Board of Chiropractic Examiners and Force Committee is being held by teleconference pursuant to the statutory provisions of Government Code Section 11133. The date is Thursday, March 2nd, 2023, and the time is 12:01 p.m. The board's paramount responsibility is to protect the health, welfare, and safety of the public through licensure, education, engagement, and enforcement in chiropractic care. Members of the public may address the committee during the public comment session. Public comments will also be taken on agenda items at the time the item is heard and prior to the committee taking any action on said items. Those who would like to provide public comment will be limited to 3 minutes unless in the discretion of the committee, circumstances require a longer period. Members of the public will not be permitted to yield their allotted time to other members of the public to make comments. Individuals may appear before the committee to discuss items not on today's agenda. However, the committee may not discuss or take action on these items except to decide whether to place the matter on the agenda for future meetings. Please be aware that this meeting is being recorded. Please turn off or silence all cell phones. We will now take the roll. Dr. Paris, will you call the roll?
Sure. Dr. Lawrence Adams.
Present.
Dr. David Paris, present. And Mr. Raphael Sweet.
Present.
Mr. Chair, you have a quorum.
Thank you. Appreciate that. And extend a warm welcome to anybody visiting with us today for this meeting, both from the DCA as well as from the BCE and in the public aspects. We welcome you and hope that you'll enjoy the meeting and make comments if you are so inclined. Agenda item number 2, review and possible approval of December 9th, 2022 committee meeting minutes. Is there any discussions or changes or additions or clarifications from the members of the committee? I will entertain a motion.
Motion to approve the December 9th, 2022 committee meeting minutes.
I'll second.
Okay, moderator, would you open it up for public comment, please?
Certainly. We are opening up the WebEx Q&A feature to facilitate public comment. If you would like to make a comment on the minutes, you can look for the question mark icon, typically in the lower right corner of your WebEx screen, or behind the 3-dot other options if you're on a mobile device. And if you are a call-in user, you can press *3 to raise your hand. In that text box behind the question mark, type the word comment and click send, or anyone may raise their hand by clicking on the hand icon. Each person will have, as stated, 3 minutes to speak. And I do not see any requests for public comment. Shall I close that feature?
Yes, thank you, Ann.
You're welcome.
Okay. If there's no other public comment, or excuse me, no other comment from the committee, Dr. Paris, will you take the roll?
Mr. Raphael Sweet.
Yes.
Dr. David Paris is the yes. And Dr. Lawrence Adams.
Yes.
Motion passes.
Thank you very much. Okay, agenda item number 3, update on board's enforcement program. I'll give this time to our executive officer, Kristen Walker.
Sure, thank you. So I just want to highlight a few items this afternoon. First of which, wanted to provide an update on our staffing in the enforcement unit. Former enforcement analyst Christina Bell retired from state service effective February 6th. So we wish her the best in retirement, and we currently have recruitment efforts underway to refill her position, as well as a vacant special investigator position in enforcement. We're also working to fill our vacant assistant executive officer position. The advertisement closed last week, and we hope to have a candidate in place within the next month. February 17th was the deadline for introducing new legislation. Staff has been monitoring quite a high volume of bills that potentially affect DCA boards and bureaus or chiropractic or other healing arts professions. As far as the enforcement program, there's 2 bills specifically that we've identified so far. The first of which is Assembly Bill 765, known as the California Patient Protection, Safety, Disclosure, and Transparency Act, which would prohibit the use of any medical specialty title by any person who is not licensed as a physician and surgeon. And the second bill is AB 1028, which is very similar to the bill we saw last session, which would remove the requirement that a health practitioner report to law enforcement when they suspect a patient has an injury caused by assaultive or abusive conduct, and instead would mandate that the health practitioner provide brief counseling and education and offer a warm handoff or referral to any patient who they suspect is experiencing any form of domestic violence or sexual violence. Both of these bills will be included on the April board meeting agenda for full discussion by the board. We also have 8 pending regulatory proposals related to the enforcement program, 3 of which are agendized for discussion today. Staff is also preparing 2 regulatory packages, the delegation of authority to the assistant executive officer and the repeal of the successful examination provision. And we expect to have those packages to DCA for review later this month. Also wanted to briefly highlight some enforcement statistics. The statistics that were provided in the handout are current as of yesterday. We've received 300 complaints so far this fiscal year, and we have a pending caseload of 451. So we're about in line with what we've seen in past years as far as the number of complaints received. Our pending caseload is lower than historical averages over the past few fiscal years, but slightly higher than what we observed at the end of the 21-22 fiscal year. So we are continuing to focus on the completion of our pending investigations and enforcement. And then as far as the disciplinary cases, so far we filed 13 accusations this fiscal year, and we have a pending caseload of 67, which as you look at the trend there, we had observed during COVID, we had kind of a cap, if you will, of disciplinary cases where we kind of spiked into the hundreds in the number of pending complaints. And as we suspected, as things began opening up and we were able to secure more hearing dates, we were able to successfully negotiate more stipulated settlements. And as we expected, that number of pending disciplinary cases is going down again. So we're now back at 67 cases. I also wanted to highlight we have the 4 strategic plan objectives for the enforcement committee. We're currently developing the disciplinary guidelines, the CPEI regulations, and the record keeping regulations at this committee level. So that's one of the objectives. One of the other objectives is that we're currently working to increase specialization in the enforcement unit by designating analysts in either a case management or an investigative role to improve our processing times. We've already designated Ms. Bell's vacancy as a case management position, and it's been advertised as such. And we're currently working with the department's Office of Human Resources to update the duty statements for our existing staff and designate them as either investigative analysts or case management analysts. Another strategic plan objective that we have relates to recruitment of expert consultants. Over the past few months, I've had a few discussions with some of our experts, and I've also reviewed the comprehensive training that the medical board provides to their expert consultants. And really the next step for us is to formally initiate that recruitment process. And after we have the assistant executive officer position filled, they're going to be assigned to manage that effort. So that really concludes my update this afternoon. I'd be happy to answer any questions from the committee about the enforcement program.
Thank you for that update. That's excellent. I think we're moving right along in our efforts. And I think your suggestion back, I think last year to take things, 2 by 2 in a sense, we're moving things along pretty well. So I think we're making some serious headway in our efforts here. Any other comments or questions from the committee?
I have a quick question. Ms. Walker, the training that the medical board provides, is that something that is we could cross-train or borrow or utilize their existing efforts to train our experts?
I believe we can, and that's a conversation I'd like to have with the medical board. We actually have one of our expert consultants did complete their program, and he found it to be very helpful because it includes training not only from the investigative staff within the medical board, but then also representatives from the Attorney General's office, an administrative law judge, and even a defense attorney is included to kind of give all perspectives and really adequate and really comprehensively train the experts. So I think with us being such a small program, I'd like to have that conversation with the medical board and see if there's something that we can leverage there and possibly use, maybe route our experts through that program just as a standard.
And then I'm sure we could, if we did provide training on it, we could really focus it on our specific issues and needs too. So that, yeah. Okay, great.
Excellent. Mr. Sweet, any questions or comments?
No, not at this time. I'm pleased with how we're moving along.
As well. Okay, excellent. There's no action that's being requested. This is more of an update. So we'll open it for public comment. Unless we don't need to do that. Usually we do.
I believe we do generally.
Yes.
Go ahead. Yes.
Thank you. So we've opened up the WebEx Q&A for comment on the executive officer's report of the work of the committee. If you'd like to make a comment, you can click on the question mark icon, type the word comment and click send, or anyone may raise their hand by clicking on the hand icon, which is typically at the bottom of the WebEx screen or behind the 3-dot other options if you're on a mobile device. And our call-in users can press *3 to raise their hand. Any comments on the report? I do not see any requests for comment. Shall I close the public comment feature?
Yes, thank you.
You're welcome.
Okay. Moving on to agenda item number 4, review, discussion, and possible recommendation regarding proposed changes to the board's disciplinary guidelines and model disciplinary orders and implementation of the uniform standards for substance abusing licensees, amending California Code of Regulations, CCR Title 16, Section 384. I'll turn the time to Ms. Pitto at this time for her update.
Good afternoon, everyone. For the past several years, the board has been working on updates to its disciplinary guidelines and model disciplinary orders and the implementation of the uniform standards for substance abuse and licensees. The committee has already discussed the trigger language to apply to the uniform standards and proposed changes to the conditions of probation. The remaining item for the committee to discuss is the recommended penalties for the violations of the statutes and regulations within the board's jurisdiction. Currently, the board broadly lists the violations in 4 categories, with the exception of Category 4, which specifies revocation as the penalty for more egregious violations and the identified statutes and regulations. The categories allow for optional terms and conditions as applicable and lists the optional terms of probation under that statement. The challenge with this general categorization of violations is that it does not provide detailed guidance to staff, the Deputy Attorney General, or the Administrative Law Judge when negotiating stipulated settlements or preparing proposed decisions, such as the NBCE exam, the SPEC exam, CCLE, practice monitor, etc. At this meeting, the committee is being asked to consider staff's recommendation to replace the categories of violations within the disciplinary guidelines with recommended minimum and maximum penalties for violations of the specific statutes and regulations within the board's jurisdiction. So with that, I'll turn it back over to the committee for discussion.
Thank you. Yeah, having read over this, I think we discussed this a little bit last time, and I'm fully in agreement with that we should direct the staff to make those specific recommendations as it relates to each category of violation. Any other comments or suggestions from the committee?
I had a few. I had a few, probably minor. Um, my first thought is I noticed that um, I think anything that is I like the language that allows the more egregious, less egregious language that we've used. So some of the violations have some flexibility to cross over um, into different categories. But I'm I'm wondering if we should consider that any sort of anything with the potential for direct patient harm um, in either clinical decision making, et cetera. I'm wondering if we should consider that those automatically be also available in category two. One specific, just as an example, in category one under CCR 317X, which I think would also tie into maybe 317P, but so I'm wondering if that thing, like that doesn't also need um, a more egregious or less egregious. I think it's an example of something that directly could affect a patient negatively. Um, and so I'm wondering if how we might figure out how to, um, allow some allowance for violations that had, might infer direct harm to the patient or overtly affecting patient care or overtly affecting medical decision making be considered category two. And I don't know if that's just adding the more egregious, less egregious language. The more liberally we're able to use that language, the more flexible these and more appropriately applied these become. That's my thought there.
So you specifically cited, somebody claiming to substitute a spinal manipulation for vaccination as an example.
Well,
So,
I specifically used it as a just a broad example of
right,
consideration, meaning
right.
like so a 317V, I would have a hard time, I think you'd have a harder time demonstrating like direct patient care, harm or potential harm or likely harm versus something like 317X or so. That may be, maybe that's the only example. Maybe I pulled out the only one that had me thinking that, but
Yeah, well, I think that makes sense though to up level that, because when you compare the two of those, that certainly seems much more egregious to me than would the others. I get your point, because that's
Yeah, I think that's a valid point, but I'd also throw, 312 and 310.2 in there as well, but maybe 317X is the most egregious example.
yeah. So, are we thinking more along the lines of using the language that gives us a little flexibility, like the more egregious, less egregious, and they
yeah,
remain in both categories?
yeah. But but when you cite that as an example, I think the one thing is that might be something that you would step up to, like a category two.
Yeah, I think something like 317X potentially. You could, not to draw that out too far with assumptions, but I think you could make a case that that could really provide harm to somebody depending on what what vaccination they were recommended or should have gotten, or and that could be just even public health. I know we're in the COVID era now, but that
Yeah.
probably encompasses a lot of things for uh, patient safety, shingles, things like that.
Yeah. Okay, suggestions then. I'm not quite sure how we modify that. If it's just a decision that we need to make, or make a motion to. If you're suggesting that perhaps it need to be upgraded, if you will. I guess that might be the term, upgraded to a higher category level of, I mean, the less egregious, more egregious kind of fits at all the levels because they kind of have a little crossover, as you mentioned.
Yeah. I guess I would ask Ms. Walker if would this potentially create a situation where somebody, like as written, a potential violation of 317X as an example could not be elevated to a category 2 the way it's written?
So just to clarify, so within the disciplinary guidelines, they're merely guidelines, but the reason that they're put into regulation is to provide the guidance that the executive officer and the AG's office, as well as an administrative law judge needs to be able to place, to assess the appropriate penalty. Even with a category 1 violation, which is what is the least egregious, we've specified a minimum of state revocation, 1 to 2 years probation, and a maximum of revocation. So it's a very wide range. So even though it's called a category 1, that's something where when we outline the types of items that are taken into account when making that decision, if it's an egregious violation, even if it is merely what we've coined as a category 1, they could still impose a penalty of revocation. And on the flip side, when you're looking at the higher category violations, even though we've specified a minimum of, say, a 30-day suspension and a 5-year probation, if there's mitigating circumstances, you can deviate and go lower than that, except for with the some of the other regulations that we're working on with the sexual misconduct cases where we're going to mandate revocation, or potentially the board could stay the revocation, but you can't go lower than that. So that's kind of how the categories all work. And if they're generally in the appropriate category, that'll work for staff's purposes. What we're bringing it today for the committee is the issue with the current version of the guidelines and the way it's the way it's listed is like, for example, category 1, there's a minimum and maximum specified, but then there's just that optional terms and conditions as applicable is very vague when you then have the entire list of all of the optional conditions. Whereas with many other boards, what they do is we can keep the categorization, but when you get into what the specific violations are, for example, like a business and professions code section 1051 under category 1, that's basically failure to register your chiropractic corporation. It's helpful for to provide more consistency if we actually specify any of the optional terms and conditions that should apply to that violation. Or in that case, if there are any, there may not be any optional conditions, and you may just, if you fail to register your chiropractic corporation, you're placed on probation with standard terms. So that's where we'd like to explore being a little bit more specific so that, within the categories, you've got your range, but then that's when we can incorporate language such as, even only in egregious cases, if we only want to apply a certain term under those circumstances. So we just want to get some direction from the committee. If there's agreement there that we could flesh this out a little bit further. We don't have to do it on the call today, but if we can be a little bit more specific in the ranges of violations or ranges of penalties for these violations, or if we want to stick with this current structure that we have where it's just broadly says the range, and then it's basically leaves it to the reader to discern what those applicable optional conditions are.
So it sounds like regardless of what category it's in, we still have a broad reach, with our discretion. And we would probably, are you saying that we would still have that broad reach of discretion within those categories, but you're suggesting that we as a committee direct U.S. staff to get more specific when it comes to those specific violations, so that it gives a little more clarity?
Correct. For purposes of the discussion, this is the last remaining piece that we have as far as the policy issues on the disciplinary guidelines. We've discussed standard and optional terms of probation and the changes we're going to make there. We've discussed the trigger language for when we impose the uniform standards. So this is the remaining piece that needs to be edited. And we just wanted to confirm that the committee would be comfortable with going in the direction of being more specific. So if we have a violation of 317C, which is incompetence, rather than just listing a minimum and a maximum and then basically having either the executive officer, the DAG, or the ALJ figure out what the optional conditions could be, you could just in plain language specify that if you have a finding of incompetence at a minimum, say you want them to take the spec examination and you want them to have a practice monitor, or whichever terms are appropriate. That way we're not having to guess from the entire menu of options.
I got you. So I think that's great advice. You already have then, it's clearly you already have some ideas of how that wording is going to go, so that when you would implement that the next time we come back, then it'll be more clear, and then we can discuss that, or at least make a decision on it and then get it to the full board, correct?
Correct. The goal is, if the committee agrees with that direction, we'd like to put together just from start to finish proposed language on the guidelines. So we would restructure it for within the categories with specific violations for the committee to discuss. We would then incorporate those changes that have already been made to the conditions of probation, and then the trigger language for the uniform standards, and basically present it as a close to final product for the committee to review and make any other necessary adjustments before going to the full board.
And you already have some language in mind, is that correct?
Yes, we would generally, we would start with what traditionally the board has been imposing as penalties for these specific violations.
Okay.
And can I
like it.
clarify,
Any other comments?
Can I just clarify these? So what we're looking at are a list of recommendations for the DAG or the ALJ. These aren't going to be required things. These are just going to be, here's what we think that you guys should look at as far as terms, optional terms for these crimes, and there's still going to be some level of discretion there. Is that the idea?
Correct. The purpose of the disciplinary guidelines is it provides guidance to all the other parties that are involved in the disciplinary decisions to be able to ascertain what the board's general expectations are for those specific violations. There's always room for either imposing a stricter penalty or a lesser penalty, except in cases where if we have a regulation that specifies the ALJ shall impose a specific recommendation, which will put that text in there. But generally it's to provide guidance so that you can get so they know what the board is expecting to see if they make a finding of a specific violation. And then they can apply some discretion, and they would justify it in cases where, if there's mitigating circumstances where it may not be necessary to impose that strict of a penalty, you would, as a board, you would expect to see if there's a proposed decision with a lesser penalty, then the proposed decision would describe the circumstances and the reasons why there's that deviation. And same with the stipulated settlement. If it's less than what the guidelines call for, then the Deputy Attorney General would provide you with an explanation of what those mitigating circumstances are, and then the board can make a decision.
Very good. Thank you for that explanation.
Thank you.
So hearing that, I'd still like to make a recommendation that we take the CCR sections that were noted that have some potential for direct patient harm, and that we move those. I mean, if they're only going to be recommended in one category, then I think we start with where we might think the appropriate category is. This process is much easier when we're all, kind of on a level playing field and like that decision making. And I think to have them starting from a category 1 is going to make it a little more difficult over time, because I think we're always going to be thinking that should always be a category 2, if that makes sense. So I'd like to, do I need a motion, or since you're still developing language, is that just recommendation that we can make back to staff? Do we need a motion to make that recommendation?
No, this is Sabina. No, not necessary. As always, your competent staff has been taking notes, and they're going to bring everything back based on this discussion, and with hopefully a more complete proposal.
Thank you, Sabina.
I think that makes sense. So I think, is that pretty clear for you, Kristen? what Dr. Paris is suggesting?
It is, if you wouldn't mind repeating the specific sections that he would like to see, because it sounds like you just would like to see some overlap. So rather than purely designating it as a category 1, allowing for that, those like direct patient harm type violations to move them up to a higher category.
Yeah, I mentioned 317.6 as the example that I utilized, but Mr. Sweet, correct me. I think he mentioned 312 and 310.2.
Yeah, I don't know if those are ones that would have to automatically. I was just citing those as additional ones that could be thought of as, potentially more harmful to consumers versus some of the other ones as you pointed out. So I don't know if those need to be included as well, but that's all I was trying to get across. Is
Right.
With agreeing with Dr. Paris.
Yeah. Yeah, things that I think what you're saying is things that have a more potential for physical harm versus, something where the, person it's more of an indirect type of thing.
Yeah. More direct and immediate, I think, affecting patient care directly.
Yeah.
I would agree with moving all 3 of those to starting them at a category 2 and knowing that we have the flexibility, because I think that infers our thoughts on where these violations should be placed to the ALJ. So then when we get recommendations back, they're more in line with kind of our general thinking here today.
Right. As a base level, right?
Yeah.
How's that sound, Ms. Walker?
That sounds great. Well, we're going to incorporate that change as well as the idea of providing more specificity on the optional terms, and then we're going to compile that to a final proposal for the committee to consider at hopefully the next meeting.
Okay. So Sabina, do we need to make a specific motion to direct staff to do those specific things, or is that just part of them taking notes and then we'll implement that and bring it back to our committee at a future meeting?
That's correct. Everything is okay as it stands now. That's still a work in progress. And when you receive the more complete proposal, that might be a better time to make a motion to recommend it to the full board.
Outstanding. Okay, committee, are you all comfortable with that direction to the staff to come back to our next committee meeting, and then we'll have more specific items to discuss and more focused as it relates to the specific recommendations for the penalties, if you will, associated with each category level.
Yeah, and I think just to be clear that there may be others in there that staff might identify under that general premise, and maybe things go down that are already up, and but I think that general idea, yeah. So those aren't the only ones. There may be other ones they identify when it comes back. Okay, great, thank you.
I concur. Okay. Any other comments before we move on to the next agenda item, or to open it for public comment? Okay. And if you would open it up for public comment, appreciate that.
Absolutely. So we are now open for public comment on the discussion that we just had. We do have one raised hand from call-in user 2. And just to let you know, call-in user 2, I'm going to send you a request to unmute, and you can press *6 to unmute yourself, and you'll have 3 minutes to speak. And you're unmuted.
Thank you. Falcon here, student intern from Life West. This is a broad comment. It's a minor, however significant note in explicitness. And it's with any note really. Particularly, like this note is was ruled to continue the discussion for it. However, in another item unrelated to this, it was ruled to continue a discussion on an official agenda item, and this was at the previous meeting. And I read the agenda put forth in the subsequent meeting, and the item that was approved to continue the discussion for with the staff was actually removed from the agenda list and placed as a bullet point in another agenda list. But it was like demoted, and I wasn't sure if did it get deleted. And the reasoning was, although the rule was to continue discussion for the agenda item, it was not explicitly said that to keep it as an agenda item. Therefore, it was removed as an agenda item priority. And there, I think, and because of such, the priority fell, and it probably got pushed back a few months. If there is a direct order, I would ask if it would be like clearly explicit about it. Particularly in one instance is like is unrelated as well, but applies the Kaiser ruling with a provisional acceptance of those licenses. I'm not sure if what was actually approved with the provision, was it prior to Kaiser changing the prescriptive duties detail or after? I wasn't sure. And it might be something like that that might be better to be explicit about. Just in the case that an agenda item that was told to be continued to discuss was actually demoted off of the agenda list because it wasn't explicitly said to keep it as an agenda item. Thank you.
And I do not see any other requests for comment at this time. Shall I close the public comment feature?
Yes, thank you, Ann.
You're welcome.
Okay, thank you for your comments. We'll move now to agenda item number 5. Review, discussion, and possible recommendations regarding proposed changes to the record keeping and retention requirements for chiropractic patients, CCR Title 16, Section 318. And we'll turn that to Ms. Walker for comment.
Sure, thank you. Just one moment here. Really at this meeting, what we're asking the committee to do is to continue the discussion of the record keeping and retention requirements regulation that we've been working to develop. As far as a little bit of background information, in 2015, the board had approved a regulatory proposal that would implement a consumer notice requirement after the death or incapacity of a licensee or the termination or relocation of a practice, including guidelines for when chiropractic practice closes and the creation of a notice of termination of practice and transfer of records form that would need to be transmitted to the board. The board never formally commenced the rulemaking process on that regulation, and that package was placed on hold. And then, as you're aware, the committee's been developing a separate regulatory proposal to address the specific record-keeping requirements for patient records in response to some issues we've encountered during disciplinary cases due to just the insufficiency of our current language and some questions around what truly is the standard in the chiropractic profession when it comes to record keeping. Given that these two proposals really overlap the same regulatory section, which is CCR 318, staff is seeking to merge the two concepts together. So within the meeting materials under attachment 2, staff has incorporated a portion of that 2015 proposal into that draft language for the committee's discussion today. And what we're really asking is for the committee's feedback on that language under attachment 2. And when comparing it to what was originally approved by the board in 2015, is this new language generally sufficient? Would you like to see anything additional added from that 2015 proposal into what we're currently working on? And really just getting an understanding from the committee of maybe their opinion on what the board's role should really be in the transfer of records upon the closure of a practice under any of these circumstances. So with that, we're generally just asking that the committee continue the discussion on the development of this proposal and specifically those sections as they relate to the transfer of records either upon retirement or closure of a practice or in case of a licensee death.
Okay, thank you. Any comments or suggestions, insights from the committee?
I have a few. I'll just start at the top, and as we move along, I'm just wondering under the proposed text under A, the first question that came to mind is once there's not a licensee involved, how does that affect our jurisdiction?
That's the key, is you don't have any jurisdiction, and that's one of the challenges. Are you referring to like after their death or the transfer of the records portion?
Yeah, like if the unlicensed heir, trustee, executor, administrator, conservator, or personal representative, none of them are licensees. So my second thought was then is it, I don't know, like how do we enforce that?
This is Sabina. We don't have any jurisdiction over unlicensed individuals, so we're gonna rely on niceties.
Guidance. Guidance.
Yeah. Shouldn't there be something in there though that that whoever, I guess, assumes in a sense that they would be encouraged to, I guess that's what you're saying with niceties, that they're encouraged to inform the board that there's been a passing of the chiropractor and that there are records. Is that kind of what we're getting at here as far as the form? Or is that more for a chiropractor that transfers or moves?
So for the purpose of that regulation that was developed back in 2015, it's a common question that we get at the board is, this is what's happened. What do we do with the records? And there's nothing, they're not addressed. So that regulation was developed as an attempt to basically provide guidance under those circumstances. And you can't really put forward guidance without putting that procedure in the regulations. As far as what we've kind of taken from that and then put into this language, we did try to address it a bit by in the proposed subdivision D1, talking about the transfer of records, requiring that each licensed doctor of chiropractic establish a plan for the transfer and maintenance of their chiropractic patient records for the minimum retention period specified in the event they become incapacitated, deceased, or otherwise unable to practice. We could consider potentially requiring that they designate another licensee, because that would keep the continuity of jurisdiction. But like you said, if it's just specifying what would happen with the unlicensed heir and what they should do, the regulation would be helpful because it would provide them guidance on what the expectation is, but we wouldn't be able to take any action if they failed to comply.
I like the idea that we have some language around a plan.
I agree.
And that it goes to a licensee. This allows for patients to lose their records and, really no enforcement, and we'd have to come back and say, oh, sorry, we can't help you with that. Or somebody just keeping the records or not wanting to transfer records or.
A plan or some other licensee that, serves as almost like a backup. Or is there any guidance from any of the other healing arts boards as to how they handle this stuff?
Mr. Sweet, that's just what I was going to recommend. I was just pulling out my other law books from some of my other boards to see if we had some direction we can possibly look at. I'm sure Ms. Walker's already looked into that. If not, that's definitely something we can do between now and then for the next meeting.
Yeah, I think in a group or a healthcare system, obviously that becomes relatively easier to come up with a plan and have compliance. It might be the solo practitioner that this is something newer for them, but.
Well, I concur that I think I like that language that we have a plan in place. Obviously, that's best practice to have a plan in place for that. So I think I would be in agreement with that. What about the assumption of risk? Is there a, if they designate another licensee, they would be assuming those records. Is there any liability on the part of that practitioner?
I think that's definitely an interesting concept that we can do a little more looking into and how that's handled. Like you already said, you know, if you're working in a healthcare system, there's, you know, a system already in place and a plan for when somebody quits or somebody is deceased or incapacitated. I know one of my other boards has some provisions for incapacitated supervisors because some boards require their licensees to obtain supervised hours. You know, so there's plans like that in place, but I think that's definitely something to make sure it's explored a little further.
Okay. So what else do you need, Ms. Walker, from us as a committee in relationship to agenda item 5? Because I think our feeling generally is that there should be a plan in place, and then maybe a little bit more insight from other healing arts boards might give us a little bit of direction and incorporate those into our regs to firm up this this particular situation, despite, you know, the lack of jurisdiction once someone does become deceased or incapacitated.
Sure. So just to confirm, so within that language that we have, the way it's drafted would require that there's the retention for that entire retention period, whereas previously it would kind of fall off the wayside if someone was deceased because you can't enforce it. So the committee's intention is for us to explore options to where we can maintain that continuity and then likely have it be designated as a licensee so that we can also maintain jurisdiction, which we can explore. And then the other piece I wanted to confirm is where do you see just generally the board's involvement in that? Is that something you'd like to see those plans that are developed filed with the board, or just simply something that has to be you know, created by the licensee, but, you know, do we expect to receive them, or do we just expect the licensee to maintain them with the records and then it could be retrieved if necessary?
I guess my thought, just hearing that's a great point, is that I think that would be probably burdensome for the board to have to catalog all that information from every practice. It seems what would make more sense is that we make it a regulation that a plan needs to be in place. And of course, as circumstances arise, if a patient calls and says, hey, my doctor passed away, I can't get my records, then that would be an individualized type thing. Then, you know, there should be, you know, an ability to contact that facility. I don't know, maybe that opens the door to that there needs to be upon a person's becoming deceased, perhaps maybe that's where it needs to go, is that upon becoming deceased, they need to inform the board that there has been a chiropractor become deceased, and that, you know, the plan is in place or not in place, something along those lines, and that because there's going to have to be a contact person. That just seems like a lot. So that seems the best thing would be to have a plan in place. And then hopefully there's still somebody to be able to be contacted if a patient were to contact the board and say, hey, I've used to see this chiropractor and I can't get my records. You would assume that would happen fairly quickly, but in the case of somebody that perhaps is, you know, doesn't come in real regularly, there might be a lapse. I know we had that situation in Sonoma. A doctor passed away, and you know, patients just started kind of sprinkling out in the community. So when we would request records, no records were being sent. So we're kind of starting from scratch. Other thoughts from the committee?
Well, I think the initial just having a regulation in place that they need to have a plan for the transfer to a licensee in California licensee is, and I mean, I think that's a good start for regulatory language. And then, you know, if we are identifying problems, we could come back and strengthen that if needed. I don't know that, I know that's happened in other areas where offices close and there's a lot of confusion as to, you know, where are my records, who, you know, but yeah, I don't know if we need to put it on, have them file the plan. I think just having the regulation in place and, you know, initially kind of running at the speed of trust, and we can always come back if it seems to be problematic. It's definitely strengthening it just as is. So I'm happy with them not having to file it with the board.
Mr. Sweet, Raphael?
Yeah, I mean, I'm in agreement. I think, I guess the concern is if, you know, I think it is overly burdensome to ask them to submit it to the board, but then the concern is, you know, if someone, you know, like you said, a solo practitioner passes away, where would this plan be found? I guess would be the concern, right? That's, I don't know if there's an answer for that, but something for us to think about, I think. But I mean, generally, I think providing this regulation, I think is going to be helpful.
This is Sabina again. I think the board should really not be collecting patient records. Besides the amount, it's just they just are not involved in maintaining and being the record keeper for patients. That's just not their role. And I think you know, we have had a lot of instances when other healthcare practitioners have passed away, and patients may be trying to get their records. A lot of times they contact the executor or the trustee of the estate, and usually things work out pretty well that way. I have seen that happen. And then most times, I think real competent and aware doctors or healthcare professionals do have a plan in place anyway, regardless of whether it's required or not. But it's a great start, and it's a great idea to check all the other healthcare boards and see what their regulations look like.
Thank you. Okay, anything else from the board?
On the whole agenda item?
No, I think just on this part, I was gonna kick it back to Kristen to continue on to the other aspects of agenda item 5.
Okay, gotcha. I have nothing else.
Nothing from me.
Okay, Ms. Walker.
Okay, so we have our feedback and our action items that we'll bring back as it relates to that transfer of records. And also within that draft text, we've started to weave in the committee's discussion about the actual content of the patient records and the creation of the file. Specifically, that's looking at subdivision A of section 318, where it's requiring that the records be documented in during each patient encounter, and then specifying what that file should contain, and then breaking it down by the initial visit and subsequent patient visits. So if there's any feedback from the committee on that language, we would take that as well, so we can bring both items back to the committee at the same time.
So having reviewed attachment number 2, I think that's referring to the additional aspects there. I think it looks good. I think it's consistent with what our discussions were last time. Any other comments from Dr. Paris or Mr. Sweet?
I had just one other question on the proposed text from attachment 1.
Okay.
Just to go back for a second, it under number 4, it notes signature of patient, and somewhat vague as to where and what document, but it also seems maybe redundant because of number 7. And I don't know if the intent is to just identify that the patient's physically present and signed some sort of document there, but I would say just signature, my question would be where we know that it's got to be on the informed consent, but maybe they've signed also in office policies, I don't know, reimbursement policies, there's usually 5 signatures or so that probably go into all of that. So I'm wondering if that can be specified more or should be specified more, or maybe perhaps that it's redundant.
And Dr. Paris, in response, that feeds in also to the language in attachment 2, which is more up to date. So that general requirement that the patient's signature be in the records is in the existing regulation. And what we've done so far is we've actually struck through basically where that current language is with where it lists the 1 through 7. And instead, at the beginning of subdivision A, we've got that paragraph, at a minimum, the chiropractic patient file shall contain the following records. We have the proposed subdivision A1 with the patient's full name, date of birth, and signature, which I see how that still can be vague, and it could either be removed or specified further. We did also by grouping those together, we removed the requirement for the social security number because there's some concerns there. We could copy it over, but to mandate that the social security number be in the file, there was when this was initially discussed back in 2015, there was concerns raised at that time about the need for the social security number. Certainly it could be collected if necessary, but for the board to mandate that it be in the file, at that time they discussed how it could be unnecessary. And then below that one, we then have the signed, written, informed consent. The proposal to add a key to any abbreviations used within the patient records, and then documentation of the initial patient visit, and then specifying what would be in that record, and then documentation of any subsequent patient visits. So that's where we're at with it now. We do need to do a little bit further development on it, but we wanted to get kind of the committee's initial feedback on that language there.
Yeah, understood. So yeah, I'm sorry, I shouldn't have used the 2015 language as my example, but I think it's the same in the new language. It's the same question. I think it's a source of confusion as to where that signature goes, and it maybe kind of infers to me that they have to sign on the initial eval or something, or I don't know, I'm not sure. So I just don't know if that's duplicative or necessary to include it twice. Probably a minor point. Go ahead.
I was just going to say, I interpreted that to be, on your standard intake forms, when people fill out, what they're, when they're kind of doing their intake form, then at least in our records, we have a signature, and then the informed consent is a separate signature. I mean, there's their signature on HIPAA, their signature on their intake form, that they fill out. There's a signature on the informed consent. There's multiple signatures. So I just assumed that was, signatures in the places that apply to those that are required. So it's not, I mean, it wasn't vague to me, but when you pointed out, but it seems pretty, it's covering the bases there anyway.
Yeah, not a sticking point. It just seemed duplicative, but or maybe we could specify where we feel like the public protection comes in and having their signature. Where is that? What documents is that? We know informed consent, but why else do we need it if they're signing informed consent?
Well, I would think one thing on the history form, when they're writing it in their own hand, or in computer, that they're attesting that what they have put in there, is consistent with their recollection or their intent. I guess I've always thought of it as that they, we have most people, they write a lot of their records in their own hand and then sign it in their own hand, so that, that's what they said they were feeling or they were experiencing at that time.
Yeah.
Then we have the section for doctor comments, which is in our writing, and we may go more in depth and get more specific, as far as it refers to section C, where, radiation or severity, they're not necessarily putting radiation or severity on their intake form. That's more we pull from them, and then we sign our part to our additional comments. I don't know does that clarify, or does that, you still feel like there's some redundancy there?
I mean, I think it's okay to have the redundancy. I think, but I was just pointing it out. But yeah, I could see the rationale for having multiple.
Would it be helpful if we specified that requirement for the patient's full name, date of birth, and signature on the intake forms, and we define what those, come up with something more specific than intake forms? But if we clarify that that's the intent there, and then also require the patient's full name on the documentation of their visit, so that way we're kind of pointing to where within the patient record we're requiring that information be. Because like you said, it is rather vague to just say there should be a patient signature. What does that mean? Where, and to Dr. Adams' point, when you're talking about the initial intake paperwork, that's much more clear that they should complete and sign their health history forms that they provide before the visit.
Yeah, I think that'd be helpful. I think it could be developed a little bit further. Can I add one more?
Please.
So on number 3, a key to any abbreviations. My first thought on this was that there are standard abbreviations that are very common throughout healthcare, and most healthcare systems or facilities or professions have very common, often used abbreviations. And I feel like having that in all the patient records could be very kind of labor intensive and maybe in some ways unnecessary, but I'm not sure how we identify for them, the non-standard. That's a common thing to be trained on, is to be trained on non-standard abbreviations and when, where you use them and when or not use them. But there's so many. I mean, everything in healthcare is an acronym or abbreviated, and everything in physical exam. I mean, even right versus left can be a capital R and a small L. It seems like it could be a little bit burdensome.
So is your suggestion to drop that, and that if a practitioner has his own kind of code, he better create a...
I just don't know that I think it might be important, maybe that it's available in the office. I don't know that it needs to be available in every patient record.
I hear you.
If that makes sense.
Mm-hmm.
Yeah, I mean, I think that somebody that comes in should be able to identify, ROLS or something and go, okay, well, what do you mean by this? And something non-standard. There's also, I don't know how we incorporate verbiage that allows for, licensees to freely use standard abbreviations in healthcare. I mean, because that is what it is. Chart notes are abbreviated. Right. Anything with more than 3 letters has an abbreviation. So it seems like it would be somewhat of a burden to include that in every patient record.
So you're suggesting to strike number 3?
Or perhaps if we believe there's a public protection benefit to having that available, maybe have it available in the office, language that...
Or upon request?
Yeah, or upon request. Yeah. That's probably really good language. Thank you for that. Yeah. Mm-hmm. I mean, I think they should be able to... We actually run into this a lot in the field, where you're reading records and they're using somewhat non-standard or maybe Cairo specific. You know, and different techniques have their own ways of doing it, even in the professionally. So, yeah, I think something upon request. That way, if there's an audit or we have an investigator out there, they can, further make sense of, what was actually done and said, etc., documented.
I can concur with that. What do you think, Mr. Raphael?
I think that seems like a reasonable way to handle it.
Okay, Ms. Walker, how about number 3? We key to any abbreviations used within the patient records upon request.
That sounds good. As far as a little background there, the reason that was included is twofold. One, many times, under the health and safety code, patients are entitled to a copy of their patient records, but in many cases can't make heads or tails of what any of the records mean if they're just looking at a series of abbreviations and symbols. The other reason being, sometimes in enforcement, we encounter cases where someone's made up their own key to what their abbreviations are. They're not necessarily using standard. And then we have issues with the experts either unable to interpret, and then we're relying on the person saying that the records say what they claim they say, but that's after a complaint's been lodged. So if there's a little standardization there as far as what the key is to what the provider is using, I think that would benefit those of us that are chiropractors when we're trying to review the records. I agree that it could be done rather than within each file, just maintaining the key so that way we could request it through enforcement and a patient could request it directly from the provider.
Okay, I think that sounds good. Any other comments or suggestions on attachment 2?
I was also just going to ask, I saw that it says that you need to inform people within 30 days via first-class mail. And I didn't know, seems kind of fast if someone passes away, but I don't know. I mean, I think we should err on the side of being a little more, get notice out more quickly rather than later. But I don't know, is that a reasonable amount of time for folks? Maybe it is feasible if there's a plan in place.
So 30 days seem too long for you?
No, I was going to say it seemed pretty quick if someone passed away to get notice out via first-class mail in 30 days. But I guess I guess I'm more proposing the question of whether that is too fast or not. I would rather we err on the side of people working on this stuff more quickly to protect the public.
So are you thinking more along the lines of maybe 45 to 60 days? Give them a little time?
Potentially. I mean, unless if everybody else thinks that's doable, that 30 days is doable, then I can be persuaded.
I see your point. I mean, sometimes people are still just kind of reeling from it. I get that. I would be comfortable with that, a 45 or 60-day period. I mean, you think about it, to get those records out to everybody I would think, well, that'd be pretty daunting for our office. We've got a lot of files.
Yeah, that's what I think. If someone just told you today, hey, you got 30 days, everybody.
Yeah. I can concur with that. How about you, Dr. Paris? What do you think? You think a little bit more time there for in the event that?
Yeah, it's a good suggestion. Yeah, thank you.
Giving people a little bit more time. What are you guys comfortable with? 45 or 60? What do you think? 60 days? Give them 60 days.
I think 60 is fair.
Yeah, I think 60 should be.
Okay.
Funny.
So, Ms. Walker, we would like to address that in page 3, middle of the paragraph there. In the event a doctor of chiropractic becomes incapacitated within 60 days. Any other? I'm sorry, go ahead.
Oh, I was just going to simply say that we'll make that change. That 30 days was a carryover from the 2015 language where they specified 1 month. So we just converted it to 30 days. I agree. I think 60 days is more reasonable.
Okay. Any other comments or suggestions from the committee relative to attachment 2 of item 5?
I was going to recommend that under I, if we're adding prognosis, that we might add in goals of care.
Pardon me, one more time?
Well, I don't see any language on there that reflects documentation to like goals of care, like treatment goals, goals of care. I mean, I think it's pretty thorough.
Well, J says treatment plan, including any recommendations or other orders.
Yeah.
Is that?
But that
kind
would
of
be, I
assume
think
that
that
was-
actually should be maybe moved up to the recommendation and or orders might be more specified in F. So like any diagnostic imaging or lab tests that are either ordered or reviewed. So it kind of encompasses, you know, if you've ordered or reviewed any documentation. I know it mentions it or orders in J, but I think when you talk about labs and imaging, you're either reviewing existing or you're recommending they obtain labs or imaging. So, I mean, either way, I think we could specify that a little bit better in F. And then nowhere on here does it mention that we're in the patient record that it's noting. I mean, we have prognosis, but we don't have anywhere, you know, goals of care. I think that's somewhat of a standard to, you know, have some goals of care.
Well, why don't we augment J and say treatment plan / goals of care,
including goals of care, and we could even add in the recommendation diagnostic.
Right, yeah, you could say, J could say treatment plan / goals of care, including any recommendation and or orders.
Yeah, I think just some language that kind of encompasses that would be helpful.
Well, let's if we can in the 30 seconds or minute we have. I mean, if you're comfortable with that, let's have them put that in there in J. Did you want to shift the order? Do you feel like J should be moved up? Or like diagnostic imaging
comes last. I'm sorry, go ahead.
Yeah, well, that's what I was thinking.
Yeah, I think standard coding, standard E&M, SOAP note, you know, the kind of the plan is like the final thing, you know.
Right.
So I think it's okay.
Treatment plan / goals of care. You comfortable with that language? I like that.
Yeah.
So, Ms. Walker, what do you think? J, we put treatment plan, goals of care, including any recommendation and or orders.
We'll certainly make that adjustment, and then we'll also make the adjustment that Dr. Paris mentioned to F for a little bit more clarity there about the diagnostic imaging and lab tests, either recommended or reviewed.
Yes. Raphael, any other thoughts or comments there on this?
No, I think that's a good suggestion. I think points well taken.
Dr. Paris, anything else? You comfortable with that going forward?
In that section, I have one more thing in the whole document.
Yep, fire away.
Under 5F, where we're identifying the full name and either the signature initials of the treating doctor of chiropractic. We have I think our next agenda item, we're discussing unlicensed. And so I'm wondering if that shouldn't be modified to also identify, I think it portends some situations where the treating doctor would not be able to sign a subsequent patient visit. And so that we should identify that, you know, the person providing the treatment is actually signing.
Yeah, we do that. We have a form, and whoever provides that that service that day initials it.
Yeah, that
So
language.
I think that should be in there.
Yeah, it seems to specify the doctor of chiropractic. So I think considering the other language we're looking at, we might want to identify that it may not always only be the treating doctor on the patient's case.
So would that be better done here or when we deal with agenda item 6, when we're going to be more specific about unlicensed practitioners? Should we perhaps be redundant and do it in both?
Yeah, I think they should
So it's
align.
clear? Yeah.
Yeah, I think they should
Okay.
align.
So, Ms. Walker, how about 5F, the full name and either the signature or initials of the treating doctor of chiropractic or individual providing care? What's a good way to word that? That it's going to be consistent with 6, with this item 6 when we get there.
We'll ensure that there's consistency between the two, as far as making sure that it identifies the person that actually provided the treatment. My question for the committee is, are you comfortable with keeping something that still identifies who the treating doctor of chiropractic, or not necessarily calling the treating, but either whether they're personally performing the treatment or they're the supervising doctor? It would be just helpful for enforcement cases if it specifically identified who that doctor is. So if you have an unlicensed individual that actually performed the physiotherapy treatment that day, they're identified either by initials or name because they filled out the note. But then if it also identified who that supervising doctor is, because we do get ourselves in situations where it's difficult for us to actually identify who is ultimately responsible there when they're not identified as well in the record.
Well, I think that's consistent with what we were talking about before, that if in item 6, also in here, that the direct order is, for example, in our office, when we set something up, we fill it all out and then I sign it. So my signature's on that direct order. And then on the back, we have listing of kind of like a spreadsheet where the date, and the time the procedure was performed, and then the initials of the person, the location, according to the direct order on the front of the sheet. On the back, it then states what time that it began, what time it ended, and then who performed it with their initials on that same form. So my signature's on it as well as whoever of our staff does it.
Yeah, I think the language should just reflect an and, so that, so we know who the treating doctor is, but, and, anyone providing care to the patient that day. If that makes sense, that way if somebody else is also providing care, it's noted.
Yep.
Not an or, but more like and type of language.
Yep. Does that sound good?
Sounds good to me.
Okay.
Thank you.
Ms. Walker, does that clarify for you? Good enough direction?
It does, yes. Thank you.
Okay. All right. Any other comments or suggestions on agenda item 5, attachment 2?
I have none.
Okay, so let it be. All right. If we can, and I don't know that we need to make a specific motion since we're still in kind of in process here, correct? I can just go straight. Okay, so I'm just going to go straight to public comment if there's nothing else from the committee.
That's correct.
Okay, so Ann, if you'd open it for public comment for agenda item 5, I would appreciate that.
This is the moderator at the direction of the committee. I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. And audio-only participants can raise their hand by pressing *3 on their device. And it does look like we have a request from an individual logged in as ML. ML, you'll be given 3 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device. All right, you are unmuted.
Hi, my comment is in regards to record keeping, and you did just address some of this, but I would like to give my public comment. Does the treating chiropractor's name have to be in patient records, even if they are working with a medical doctor supposedly doing physical therapy? What if the chiropractor's name is nowhere to be found in the medical record, even if the patient was treated by that chiropractor, not a physical therapist, nor particularly the medical doctor? In my case, my medical records state that I went in for physical therapy, but I went in for chiropractic care with adjustments and some physical therapy elements. My chiropractor's name is also not mentioned anywhere, only the MD who co-owned the practice. Are chiropractic adjustments included in what's being billed for physical therapy? It's possible this practice may be billing for physical therapy under the guise of chiropractic care. My records seem strange to me. I am awaiting a response from Ms. Walker on this question, as I have discussed this with her. Thank you.
Thank you.
All right, this is the moderator. Appears there are no further requests for public comment. Would you like me to close that Q&A panel?
Yes, thank you, Sarah. And I apologize for calling you Ann earlier. I didn't know that we
it's
had
okay.
switched it up. So
I'm
apologize for
just
that.
covering. No, it's okay. I'm just covering for a little bit.
Thank you. Okay. Ms. Walker, I'm assuming that that's being handled, the public comment by you, and that there's no reason for us to comment on anything at this time.
Yes, it'll be handled when we get to the future agenda items. If the committee would like to discuss any of the issues raised in the public comment submission, we can agendize them as well for a future meeting.
Okay, thank you. Thank you for your comment. Okay. There's nothing else from the committee. I'll move to agenda item number 6. Review, discussion, and possible recommendation regarding the authorized activities performed by unlicensed individuals within chiropractic practice, CCR Title 16, Section 312. And I'll turn the time to Ms. Pitto to bring us up to speed on this one.
Thank you. So a little background: at the August 29th, 2016 board meeting, as part of a planned comprehensive consumer protection enforcement initiative regulatory package known as CPEI, the board approved proposed language to amend California Code of Regulations, Title 16, Section 312, Supervision of Unlicensed Individuals. During the December 16th, 2021 board meeting, the board voted to divide the CPEI regulation package into 6 proposals grouped by topic. Section 312 was separated and placed in a single topic proposal. The purpose of the proposal to amend Section 312 is to clarify the role of and delineate the activities that can be performed by unlicensed individuals within a chiropractic practice, define and establish the supervision requirements by a licensed doctor of chiropractic, and require that unlicensed individuals follow and provide only the treatment defined in the supervising doctor of chiropractic's treatment plan. At the December 9th, 2022 meeting, the committee discussed the proposed language that was approved by the board in 2016, the role of the supervising doctor of chiropractic in the preparation of the orders and treatment plan, and requirements for the licensee's physical presence at the facility. The committee also discussed prohibiting former licensees whose licenses were revoked or surrendered from performing any unsupervised patient treatments, and noted how the terms work week and readily available are too vague. Following the meeting, staff gathered summary research on similar requirements from other states. Staff notes that Rule 78.3 by the Texas Board of Chiropractic Examiners concisely summarizes the roles and responsibilities of the doctor of chiropractic and unlicensed individuals. Staff also updated the proposed language to reflect the committee's discussion. At this meeting, the committee is being asked to review the summary on similar requirements from other states and continue the discussion regarding the proposal to amend Section 312 and provide feedback to staff regarding if any additional changes should be made to the language or if there are any examples from the other states that the committee would like to incorporate into our language. So if the committee comes to a consensus on the policy, this can be moved forward to the board for consideration, or if there are any questions or changes, staff can address and bring this back at a future committee meeting. So I'll turn this back over to the committee for further discussion.
Thank you, Ms. Pitto. Appreciate that. Okay. Let's open it up for discussion regarding these proposals. I think we've come a long way in this and had discussions in the past meeting, and I think we're close to coming to a consensus on some of these provisions that will make it in the interest of public and protection, as well as to the profession as well. So I'll open it up for discussion and for comments from the committee and suggestions.
I have a few. I mean, the more I think about this, I have a few general concerns, and so I guess I'll start with my overarching general concern is that, you know, the high variability that we might see in training and establishing competency for you know, activities that are unlicensed unlicensed folks doing activities that chiropractors go to you know, a DCP program and spend literally semesters in that professional program going over these things and learning how to do them, performing services that MBCE has actually established testing standards for, and that we test out to establish competency, you know, through MBCE. And so I have reservations about allowing those to be performed without some acknowledgement of like some sort of training established. And I think if we leave that to the field, then we have 12,300 different ways to do that and to sign off that training and to establish those competencies. And I'm not sure that's in the best interest of public protection. That, you know, so I think the discussion I'd like to have is just, you know, can we strengthen that so that we have some assurances that these, you know, unlicensed individuals are trained in some way to provide those, you know, those therapies, modalities, provide that treatment when the, you know, DC is, you know, there is no direct, you know, indirect supervision, you know, in the cases where they're not in the office. I think that's a completely different situation than when they're receiving direct supervision. And so that's kind of my first broad, I think, discussion point.
So I take what in reference is that the training is kind of the overarching theme to what you're saying, is that, you know, that we have these items that we went to school for, and then that we're delegating that to somebody that may or may not have that extensive training. And I agree. As I looked over the information provided by the staff in the back of this item, you know, looking at all the different things that the different states do, boy, you know, there's a lot of consistency and a lot of inconsistency in a lot of the way the states have done it. So and so perhaps the answer to that is really coming back to continuing education for, you know, perhaps a CA course. That I saw some of the other states implemented, that, you know, that it was a state licensure board approved program that the unlicensed practitioners or CAs or CA course went through. that could be specifically delineated out into those respective areas. And we haven't, I mean, the state hasn't really done that before. So they've always relied upon the practitioner to train them in accordance with how they do those practices in their office. So your concerns would affect, obviously, this attachment going forward, if there are things that we need to implement that are gonna, because this is more assuming that they're getting trained by the practitioner in the office in the procedural aspects that they want them to perform.
Yeah, I think, I did a little background, and we have, our respected national organizations that have taken this on. And so FCLB has a program where, they certify the providers of this type of chiropractic assistant, using that terminology just initially here, but they certify that type of chiropractic assistant programs, and they do it through CE providers, but also through colleges and state associations. And so I think that it's available. The length of the programs, which when you look at all the different states in here, the ones that have language pertaining to this, most of them align with the same, 24-hour educational program. I reached out to see if there was, because obviously if you have existing staff that have been trained and been in an office and maybe been doing it for a long time, they do have an exception, an hours exception of working in a chiropractic office, where you'd still be eligible to go take the certification test through them. And I thought the cost and the pricing on those was reasonable, and likely wouldn't represent a large burden, to have an office, have somebody trained in doing this. I also felt like when you look at the majority of the states that have language around this issue, that most of them require, I think the majority from my count, required some direct supervision. And so I think as we discuss the idea of indirect supervision, it brings, in my mind, it brings the public protection issue even more to the forefront, and that we should consider that it's somebody trained in cases where there's maybe some indirect supervision, along with some sort of frame that, now we don't have patients who are seeing my doctor in 6 months type of, issue that I could envision perhaps going on. But so I'd like to see some language around, unlicensed individuals, or, those chiropractic assistants having some training in those things. And that's my support for that. For my argument is that these are things that aren't as flippant as they seem sometimes. These are things that actually we take a MBCE test for, the physiotherapy test, and even, and I would say just secondary issues on this same topic. One would be, if we mandate BLS for DCs in the office, but there's no DC in the office, who's doing the BLS? So I think we have to consider that too, that, these trained, assistants, these CAs, would also be trained in the emergency procedures that might need to take place in office. And the FCLB certification, only naming them as an example that I researched, but they also require that there is some continuing education. I believe it was 6 hours every 2 years, which I think is more than reasonable, as for that particular training. Yeah.
Okay. Mr. Sweet?
Yeah, I mean, I think that's an important point. I was, in reviewing the Texas code, they have it listed out as a qualified individual that requires adequate education, training, and skill to perform an act. So, and then they also later on say, the licensee shall document that an individual is qualified to perform an act. So, this is maybe, I know we don't always like to take a lot of direction from Texas, but maybe this is something where we could adopt something like that to, rather than just saying some person who's not licensed and leaving it at that. So I think Dr. Paris raises an important point, but overall, I was encouraged with the changes along the lines of what you were saying, Dr. Adams, that this is represents significant progress, I should say, and I think we are getting closer to where we need to be.
Agreed. Yeah, I certainly can be on board. I think that that perhaps we need to implement that. I think that's probably just a section that says that the unlicensed individual needs to be properly trained and cleared, and we can't leave that to a person shows them, okay, here's how you do this, here's how you do that, okay, now go do it. That's pretty and that may be in some cases what's happening, and then a person just gets familiar with it with times. I like the idea of the fact, like I think of the staff that we have in our office, they haven't been to a course, but they've been with us in some cases for 6, 8, 10 years. And so they've been doing certain things for a long, long time. So hopefully there would be a provision. I would be in support of a provision for the fact that if a person has, in excess of, a certain set of hours doing certain things in the office, that would be, perhaps grandfathered in because they've reached a level of their proficiency because they've done it for many, many years. But I also think it'd be good to have in place that people do, get certified or qualified through an approved, structured course where they're learning specific things about, for example, history taking, examination, those types of things. And then also rehab or physiotherapy modalities. I don't want to take away from what the work the staff's already done. So I think those are things that can be kind of plugged in here and qualify a lot of the other stuff that we have there in place. So having said that, my one thing is that I wanted to point out where we have it would be, let's see, that's C, looks like it's, what do we classify that? Oh, 3. So under 3 on page 2 of 3, physiotherapy, I think we might want to say in there, so it's not only just focused on physiotherapy, but that could be, physiotherapy or, rehab suggestions or other things like that along the lines of what we were talking about. So it's not just specifically trying to say that an unlicensed individual can only do physiotherapy, because we also might have them instructing a patient on proper lifting technique or rehab exercises. And so that language should reflect that. Also, I'd like to suggest that where we talked about the licensed chiropractor shall be physically present in the same chiropractic facility with the unlicensed individual, rather than saying it on a weekly basis, that we might look at a monthly basis or hours that the office is open. So 25% of the hours that the office is open in a given month. Therefore, if a doctor perhaps goes on vacation, that they're not locked into that time per the week, but also under direct order of the doctor. And then I really like the provision there of the licensed doctor, the doctor that has implemented the order needs to be on call and readily available. I think that we've defined that, which I like, that they should be able to be contacted within 15 minutes. And then certainly, I think that they've put on there, number 4, the doctor will perform periodic reevaluations. Periodic is every 30 days. And I think there was one other thing, and Dr. Paris, maybe you can help clarify there, that we had thought about when we were discussing this last time.
That might be regarding the periodic reevaluation under 4.
Yeah, but also that if there's a change, there was something, and I think it's in here. I read it in here. There was, if something changed, like if something new happened that the staff could not, that they couldn't move forward without contacting the directing doctor to let them know of the change and allow the doctor the opportunity to either via teleconference or to address that if they were not in the facility before the set. It's something along those lines. And it may have already been in here. I know I read it. But
the concern was the change in patient condition or status.
Correct. That's it. Yeah, change in patient condition. There's a change. Yeah. So a follow-up visit, if there's a change in patient condition, that there needs to be that order needs to be not acted upon until the licensed doctor has addressed the change in condition. And for some reason, I thought I read that in here, but maybe it was on the Texas. Maybe it was, I've read a lot of things in the last 2 days. So
yeah.
Does that make sense, Ms. Walker? Something about, that if there is a change in condition that we need to have that provision in there.
Yes, that makes sense. And I believe you may be referring to the minutes of the previous meeting, so we can make sure that we language around that into the draft text.
Yeah. Did you add it in there? I guess maybe I'm not seeing it, or I'm meshing the two together. I didn't see it in there, but that should be. I think that should be in there. That if there is a change in condition, that there needs to be a reference to either the licensed doctor that is on staff, because I'm thinking in terms of if the doctor that had directed the order is, say, out of the office there, and there's a doctor on staff, that person obviously, another doctor there could evaluate that and then make recommendations to the unlicensed individual. But also that the doctor that if they're, say a solo practitioner, that if they are out of the office, that they need to be accessible within 15 minutes so that the doctor can discuss that and assess that with the patient, either via tele or aspects to modify that.
Could I make one suggestion for consideration on the on-call within 15 minutes? I just want to make sure we're able to clarify that there's that potentially we don't have somewhat of a more emergent situation and the patient is subjected to 15 minutes of wait time. And so I don't know how we phrase that, but that would be my concern, that there's maybe some sort of emergent issue and potentially patient harm or has occurred or might occur. And we have, unlicensed individuals treating them, but having them just wait. I think we've seen this in other arenas where part of the patient care issue is not acting, in a timely manner or appropriately. So I'm not sure how we create that language. I surely think, the expectation that you have to answer your phone right away, or every time, that's probably unrealistic. But I don't know how we phrase that to give us assurances that we're not going to have patients inappropriately waiting for maybe a higher triage, like medical decision, because we're waiting on a callback.
Yeah. Well, we certainly should have it in there. That goes to your comment about, the BLS issue, but also that making sure that our staff that is there in the event that we're not there and somebody's in there receiving a procedure and there is an emergency. that the emergency system should be activated immediately. I mean, we would like to think that's common knowledge, but it might not be as common as we think. So I don't know quite how to word that, but I think that that's something that we should consider, Ms. Walker, to include in that provision somehow. Do you have any suggestions, Mr. Sweet or Dr. Pierce, as to how that wording might be to help the staff, or just perhaps they can look at other boards?
I mean, off the top of my head, I'm just thinking something along the lines of, you know, on call and readily available to address any emergency situation, not to exceed 15 minutes, something like that, or maybe even leaving the 15 minutes out. I'm thinking out loud.
Yeah.
I mean, if I'm having an unrecognized stroke because we have unlicensed providers there, I don't want to wait 12 minutes.
Right.
You know, like, yeah, I don't want them to like have to FaceTime the licensee to show them a picture of my face to get me help.
Well, I mean, I guess maybe we got to think about any situation where you're in a situation where there is a perceived emergency situation. I mean, maybe that's really what we got to think of it as, that if there is the provision in there that's that if our staff is in a position where an emergency, I mean, I guess I'm thinking yeah, I mean, you know, that we got to be careful with the language there, but yeah, I mean, I think something along those signs that in the rarity that it does happen, obviously, that there needs to be some direction there.
I think we can come up with language. I do agree with you. It ties in well if we can strengthen it with that the office staff is trained in emergency procedures, BLS.
As well. Yeah.
That way they have been trained to understand what is an emergency and requiring, you know, more immediate care response.
Yeah.
So we may be able to, you know, add that into the language, you know, as the exception to allowing a 15-minute wait, you know, anything representing an emergency or requiring, you know, BLS or immediate care.
Yeah. I guess we were always thinking of the 15 minutes was like, you know, that if the unlicensed staff had a question about something when a person comes in, I was thinking of more about your mundane things, like, you know, it happens all the time. People come in that, you know, hurt their knee over the weekend and they're getting their shoulder worked on and they're like, hey, by the way, can you do that on my knee? And the staff is instructed to say, no, I can't deviate from the order that the doctor's given. Let me step out, talk with the doctor and let him know. And then my answer to that is we'll tell them, you know, continue with the shoulder. And then when I'm done with this patient I'm with, I'll bounce in there and I'll check the knee and see what needs to be done and write a new order for that. But you're talking more about, you know, an unlicensed individual's in the office getting a procedure and then has an emergency. Correct? Is that kind of what you're talking about?
Yeah, because I think in this paragraph that we're actually looking at is under the indirect supervision definition.
Yeah.
So I think it's important that we kind of detail it out here. I agree with you. There are scenarios, even if you were not present at the office, where they may be able to step out and call you, and it's acceptable to wait and, you know, answer a question, you know, surrounding, you know, treatment of patient care.
I think maybe what, you know, the language might be, and I really don't know how to put this in there, so I'm going to defer to you on that, Ms. Walker. But something like, in the event of an imminent emergency or an emergency circumstance, and the licensed doctor is not on the premises, the emergency activation system should be initiated. The EMS system should be initiated, something along those lines. Is that what you're kind of referring to, Dr. Paris? Is that right, kind of?
Yeah, I think that's the concern. Just some language that identifies there's likely going to be situations where we would not want to infer that it's okay to, you know, call the doctor first when you should have called, you know, 911.
Right.
Yeah.
Does that make sense, Ms. Walker, what we're looking at?
Yes, yeah, we can include something to that effect in the language, and I think it's also going to tie into the earlier discussion on what the training requirements potentially are before someone's able to independently practice, because they need to be trained on what to do as well.
Right. I think that actually fits in really well, that they're trained BLS as well as, in the areas that, an accredited or a specific program that's approved by the board that would, be a quote chiropractic assistant type course, if you will. Did you have an idea of well, maybe we don't need to get too granular on that, to use your phrase. We can look at what other boards are doing and what those requirements are, whether it's 24 hours. I kind of like the idea that every 2 years, they need to do 6 hours of some sort of training. I mean, that's, seems reasonable to maintain it. Any comments about my suggestion about the change from a 25% per week to a 25% per month of the office hours open? That was kind of a discussion between Dr. Paris and I subsequent to last meeting, a little bit about, what would be, acceptable that still kind of meets the spirit of, a doctor needs to be there. It can't just be one of these things where they see the patient once and then they might not see the patient for 6 months. Beefing it up a little bit with the 30-day reevaluations and the timing. Any more thoughts on that, Dr. Paris or Mr. Sweet?
I think as a package, I think individually there's probably some, there's something that comes up with each one single piece, but I think as we just went through, as a package, I think this really like provides the full patient protection, at least in my view. So, I like it that it's all, we're going to do it all at once. So I think that's what provides the assurances here.
Yeah.
So are you comfortable with the 25-hour, the 25% based on over the open hours in a month? What we talked about, that change?
Yeah, I like that. I think the month provides a reasonable flexibility.
Yeah.
As you mentioned, like, we wouldn't want to be, we want the patient protection, but at the same time, not to be so unreasonable so that you have weeks, what if you get sick for a couple days?
Yeah.
And you have to be off, and now all of a sudden you have to close your practice, instead of, so
Right.
I think the month provides some time to make arrangements or to, have assurances that that's met.
Mr. Sweet?
Yeah, no, I agree. I mean, I think they did make a little bit of a change of just designating it as 25% of the facility's patient care hours. But I think, which I think kind of addresses your issue of not just based on a 40-hour week or a 50-hour week, it's just the facility's patient care hours. So I think that I'm comfortable with, and then changing it to a month, I think that makes sense. I don't have an issue with that as well. So I think we're on the right track.
Excellent.
I think
Okay,
one other
having said that,
consideration.
go
Sorry,
ahead. Yeah.
can I add one? Just
Absolutely.
one other consideration might be that if we want to consider the possibility that a unlicensed individual is not required to be in the office at the same time as the provider, the licensee. And I don't know if that's, the intent or if that's something we should consider, that so, they feasibly may never interact. And I don't know if we want to consider language that requires them to be in like that 25% is that they're in the office at the same time for, patient review, chart review, updates, billing and coding stuff. I mean, I could think of, patient safety. But so I don't know. That's my only thought when I think about this. I think, okay, so the unlicensed individual could work for years and never actually see the licensee with the language as is.
I guess I don't know. You always seem to pull stuff out of there that I don't see, and I guess I'm always thinking, you got your unlicensed staff are usually hourly, and they're usually there. I'm just assuming that if the doctor's there, I don't know. I think that gets a little bit. I don't know how you would. So would you? I'm not sure what we would say there, that the unlicensed staff is in the office the same hours, or
Yeah, present, at the facility with unlicensed staff. Something along those lines. I mean, we may want to just look first. Maybe we don't need it, but I'm thinking of like other mid-level providers like physician assistants, et cetera. I'm not sure what the oversight language is. I'm not sure if that just requires, like physician chart review to make sure everything's going okay, or if that's actually, something where they have to be present face to face in the clinic. And even if they do, I'm not sure. So maybe we could get something like look at other, areas where there's some oversight of these kind of extenders that way.
Yeah, I guess I've always thought, is that I would think that in most offices, I think that would be a rare, rare, rare thing that a licensed chiropractor, first of all, I've been in practice for almost 28 years, and it would be rare that my time in the office was less than, 90% physically in my office in a month's time. And I think that's probably the case with most chiropractors. I would think there's, I don't know that that's a concern. I understand your concern. I don't see it as a concern per se, because I think that would be an enormous rarity that a chiropractor would not be crossing paths with their unlicensed staff, to where they would not
Does
really
that
be
make
able.
it easy? Does
What's
it make
that?
it easy? I mean, does it make it just easy to comply with language that if we put it in there? Do you know what I
Well,
mean? Like I'm
I know
flipping it. I'm saying, okay.
I get what you're saying, Dave. For someone that uses that term granular a lot, sometimes it gets, but I hear you, and I want to respect that, because I'm all about, I want to protect the public too. I wonder sometimes if we're, but I understand what you're saying. I don't want to gloss over anything. I want to make sure that we're all feeling good about it. I feel good about the language. I think it's consistent, in my opinion, which is protection of the public, and looks at, making sure that that those things are happening. But I'm always open to I get there's people out there. You hate to think about it, but there are people out there that are gonna, I wish they weren't, but they are. So we have to protect against those possibilities.
I mean, again, going back to the other side of this, I think the language strengthens it as is, and if that's something that concerns us, we could strengthen the language further later. It does feel a little bit in the weeds, and kind of how would that get monitored? I'm not so sure, but I'm not so sure that other professions require what I'm speaking to. But I would be interested in finding that out, just as an aside.
Well, I don't know that I agree with you. I don't think that they do per se, but I don't know for sure. So I can't say that. I can't fully make that comment, but I think this strengthens it. I think this strengthens it a great deal. And certainly we've operated for many, many years under the way it was before. So we're making it stronger. So if, you know, I've practiced this many years, so have you, under it is, and then we're making it stronger. I can't help but think that that's better. And we certainly can make it stronger as we go forward, and certainly the staff can give us some suggestions. I'm comfortable with it as it is to move forward with it. And if, you know, then that way we can maybe clean it up and bring it full circle at a subsequent enforcement meeting, where once we get some more language from the staff.
Would it be okay to see if they, and Ms. Walker, would it be okay to develop just 2 versions of that? One that kind of has that second language, and we could look at them both and kind of take some time to do some investigation and then see if we really think it's necessary or not. I mean, reading the language, we may go, oh yeah, that's just too much. It's, you know, it seems burdensome. But then, I don't know, reading the language, we might say, oh yeah, that's easy. They do it anyway, as you were saying. So like, it's easy to comply, you know, et cetera. Would that be okay?
Yes, certainly.
Okay, excellent. Are you comfortable with that, Raphael?
Yeah, I think that's a good way to approach it. I mean, and then we can look at compare and contrast.
Okay. Okay, so we're on our timeline. So is there anything else that we need to comment on or suggest for staff relative to agenda item 6?
I would just compliment the staff. That packet, especially for that agenda item, was really, really helpful. There's
Great job.
I
concur. So I think we're getting closer, Ms. Walker, wouldn't you say?
Yeah, we're getting there. I think we're going to take all of the feedback from today and hopefully we'll put together a few different options for the committee to discuss tomorrow. I would say that the biggest hurdle remaining is going to be defining what the minimum standard would be for the training requirements. But we'll develop a menu of different options, because it sounds, from what I'm getting from the discussion, the committee would like to see multiple pathways to where you would qualify. Not simply designating one certification type course, but also being able to rely on experience. We'll put together, we'll review some of the other boards and what they've got in place, and then we'll look at some of these other state examples and put together a few options for the committee at the next discussion.
Okay. Just real quick before we end, did you have a thought in mind, Dr. Paris, as to hours that, for instance, you know, that a CA that has been in the office? Did you have an idea in mind, like, you know, if they've worked in the office for, you know, a minimum of 100 hours, something along, I mean, were you thinking something along, just to give the staff a little bit of direction, what you were thinking? In addition to a qualified program, I mean.
Yeah, so the programs were 24. I think that's more than reasonable. And that's what that's what a lot of the states reflected, even in their own language. And I think that's all built around that. And then the opportunity to test without having the educational portion was, I think from FCLB, and we could probably send that to the committee or post later, was that information, but I think it was 2,000 hours. So that seemed like a lot. I didn't calculate that out into how many years that was. But it seems like that was probably equivalent to like 5 years experience or something, I would think. But and I'd be open. That seems like a lot. I think you should be able to at least have the opportunity to test, you know, and demonstrate your competency on the test. I don't know that you should have to do 2,000 hours to demonstrate your competency. So yeah, I'd be open to us, you know, thinking about that further.
Now, did you have any provision in mind for people that, say, have been working at an office for a certain amount? Were you wanting them to have a test to verify their proficiency, or were you comfortable with somebody that had been in an office for many years, like, you know, say 5 years or more, doing chiropractic assistant work?
Yeah, I'm just referring to when I did do some background, I was referring to what PACE for their certified chiropractic assistant program, the requirements that they have. And my understanding is, and I don't want to misstate this, but my understanding was you either do their 24-hour educational program and then you can test, or they offer educational programs. They just certify the programs, and there's numerous programs, state associations, continuing education providers, colleges, et cetera. Or if you can verify 2,000 hours of experience, then you could take that experiential training and that will satisfy the ability to test. So when I say test, I'm referring to the same test through them that would get you certified. Yeah.
Right. So you're wanting there to be an actual test, not just somebody that's got experience, and that the doctor says, hey, they worked for me for 10 years, they got experience, and attesting to that. You're looking for a specific.
Yeah, I think
they pass a certain accredited test or a qualified test.
Yeah, I think only because it's easy, my understanding, and now kind of like the way we do our CCLE testing, it's fairly on demand.
Yeah.
There's no wait, and I think it brings the ability for us to have consistency and kind of an understanding, that okay, everybody's at this level. That's the reason I like it. But I understand somebody that's been in office for 10 years bristling at the fact that they have to take a test. I completely understand that. But I think for our sake, it might be valuable.
Right. Okay. I got it. Okay. So I don't know that we have a specific motion here because we've given staff direction. Am I correct with that, Ms. Knight?
That is correct. You'll have much more to look at next time this comes back before you.
Yeah, excellent. Okay, so I believe, is it Sarah or Ann? Can we open it for public comment for agenda item 6?
Exactly. I am back. This is Ann Fisher, moderator, and we're opening up the WebEx Q&A to facilitate public comment. If you'd like to make a comment on the discussion from item 6, you can look for the question mark icon, click that, type the word comment in the text box and click send, or anyone may raise their hand by clicking on the hand icon, and our call-in users may press *3 to raise their hand. Each person will have 3 minutes to speak. And we will start with the request to speak from calling user 2. I'm going to send you a request to unmute. You'll use *6, and then you'll have 3 minutes. You're unmuted.
Hi, Falcon here, student intern from LifeWest. This particular item is applicable to at the college level. In regards to what a doctor order is versus what a non-doctor order is. There are some items, or there is an item that is specifically a doctor order that has been categorized as something else that a non-doctor can order instead. And if left specified, then what that implies is that the non-doctor is given doctor power without the need for consent from the doctor. The precedence that establishes is in regards to public safety is that you have unlicensed staff conducting doctor orders that shouldn't be conducting by doctor orders, and it's simply because it's not specified in the rule book at the college level. Therefore, specific, for example, is the difference between like a CPT code 99213 versus a CPT code 99212. 99212, a medical professional can bill that without a doctor's signature, but a medical professional cannot bill a 99213 without a doctor's signature. And there's some doctor orders that are specifically requiring doctor's consent that is actually being billed as a 99212 instead. So it is implying that yes, there's current instances where doctor tiered orders those powers are given to non-doctors. So what the public thinks then after they get out of the office is, oh, so you went into the office, CGC. Oh, just staff. It wasn't a doctor order. When, if it was a doctor order, then maybe it's probably good that the patient knows that was a doctor order and versus not a doctor order. Therefore, I would like to follow with the progress made on this edit. Thank you.
Thank you. And our next request for comment comes from someone logged into WebEx as ML. I'm going to send you a request to unmute your microphone and you'll have 3 minutes. You're unmuted.
Hello. Firstly, I was told at least part of agenda item 6 is today. Item 6 discussion would be about revoked licensees continuing to work with patients in an unlicensed capacity, especially in regards to sexual misconduct. Why wasn't that addressed? Secondly, I do not agree with 25% of the doctor's presence is enough. Thirdly, Mr. Adams said licensees aren't not crossing paths with staff often, but there are offices where this happens. You may think it's burdensome, but I believe that there are offices where ethics aren't their main priority. I have an office to recommend to you where this happens. Thank you, Mr. Paris, for your concern for patient safety, as in my experience, it revealed what happens when there isn't specific oversight or regulations. I thought I was one of the reasons number 6 on your agenda existed today. I'm the one who brought it to the board's attention regarding unlicensed individuals who have been basically someone who's continued to work with patients after their license was revoked for sexual misconduct. Your regulations need clarification between someone unlicensed for egregious reasons such as losing their license and chiropractic students or assistants. For example, in my scenario, the administrative law judge said in her decision and order, protection of the public requires that respondent's license be revoked, and it would pose a risk of harm to the public to allow respondent to continue to practice as a chiropractor, even with restrictions. It seems this former licensee still works at the same practice, supposedly doing physical therapy. It appears he is interacting with patients as he has new Yelp reviews indicating his title as doctor. And if they work at an integrative practice that does PT and or chiropractics, how will you enforce this? How are you going to inform licensees or of regulation changes when you meet them? Another one of your licensees, Lincoln Carrillo, last year was recently accused of sexually assaulting at least 7 women. As of your present regulations, it seems he cannot work as a licensed chiropractor, but he can work in the capacity of an unlicensed assistant. How is that okay? And why are there no public records on his licensing profile? Did none of the patients come forward to the board? Therapy definitions, questions, and comments. How do you define physical therapy versus physiotherapy? Where is the line between a chiropractor being allowed to do physical therapy or physiotherapy versus an unlicensed person doing PT versus a doctor of physical therapy? I called the Physical Therapy Board of California, and they said to request this information from your board. However, it seems maybe these 2 boards may want to work together on what appears to be a confusing delineation. Thank you.
Thank you.
And I do not see any other requests for public comment at this time. Shall I close the public comment feature?
Yes, thank you.
You're welcome.
Can I just make a comment on what was on the agenda today that we went over? I would just, to the first caller, I would appreciate it if you might reach out to board staff, and I would be interested to see the reference that you're utilizing in regards to the 99212, 99213 E&M code distinctions that you mentioned. And to the second caller, thank you for your comments also. I would note, if you look at our agenda item 6 attachment 2, and if we look at section number 5D in the proposed language there, supervision of unlicensed individuals, I think that language in D is what will strengthen our ability to address at least partially address the situation that you mentioned. So I don't know if you had seen that. And in regards to the term physical therapy is a licensed profession, and physiotherapy is often used so that the public is not confused when the term physical therapy is used in a chiropractic practice. And it's only meant to designate that there's a lot of overlap in the profession. So anyway, I hope that's helpful.
Thank you, Dr. Paris. In light of Dr. Paris's comments, do we need to reopen for public comment, or can we move forward with agenda item 7?
This is Sabina. You're welcome to do either.
If I know we're over time, but I feel like in the interest of the public interest, I think I'd like to just open it up for public comment in case the second caller had a comment, and if we can restrict the time to 2 minutes. Are you okay with that?
Yeah, I am. If you're asking me, this is Sabina.
Yeah. Moderator, could you just reopen for public comment in case the second caller wanted
Yes.
to, and then if we could just
Thank you.
restrict that time to 2 minutes, thank you.
Certainly. So ML, I see your hand up. I'm going to send you the request to unmute and you'll have 2 minutes.
Hi, I'm not certain what document Mr. Paris is referring to. The only document I have is the agenda for today, which was notice of teleconference enforcement committee meeting. There's no number 5B or anything on there. And then secondly, if you could indicate where I can find that or email that to me. Ms. Walker has my email, and also Ms. Walker indicated to me that my concerns would be discussed today, and I'm not sure why it's not being discussed. So I know I can't communicate with you guys directly, so that I guess we'll have to do. Thank you.
Thank you. So the item that Dr. Paris was referring to is that not on the website? I was under the impression that the full agenda or the breakdown would be on the website. Is it not, or is it just?
The materials are posted, and I'm sending an email to ML right now with a PDF copy of those materials.
Thank you.
So, appreciate that. Yeah, it's item on the agenda. It would be item 5. Let's see, not 5. Let's see. Yeah, 5D on page 3 of agenda item 6. Okay. So we have some good direction. Let's move on to item 7, public comment for items not on the agenda. Ms. Walker, if any written comments have been received for this agenda item, this might be where this is being was meant to be addressed in here because you sent the public comment out. So I'll turn the time to you on that.
Yes, we received a written public comment from ML. During the call today, she's reiterated the various points within that comment.
Yes.
We can also take verbal comment if she has anything to add.
So thank you. So inform members, you may address the committee at this time, advise the public that they're identify themselves as voluntary and their name may be recorded from the official minutes of the meeting if it's provided at the time of their comment. So we'll open it for public comment on agenda item number 7. This was the public comment submitted by ML for discussion.
Correct, and we've opened up the Q&A feature for public comment, but ML also does have a hand raise.
Yes.
Would you prefer 2 minutes or 3 minutes?
3 minutes. We'll go back to standard 3 for this item.
Thank you. So ML, I'm sending you your request to unmute your microphone. You're unmuted.
Yes, I thought some of my written comments may be brought up for discussion today, but I can reiterate some of them. Regarding inconsistent public document posting, why is the board inconsistent with which licensees' public disciplinary documents they upload to profiles and when? Your present enforcement manager, William Walker, told me they do not post public documents, which I now know is incorrect information. Ms. Walker has informed me that they do post these documents, but it seems that everyone is confused because my assembly person's office had to reach out to the DCA in order to get your board staff to post it. The only reason the former licensee who committed misconduct against me, his public documents have been uploaded is because, like I said, my assembly person contacted the office, the DCA, and they told her and I quote, the lack of documents related to Mr. I'll keep that anonymous, administrative disciplinary case with the Board of Chiropractic Examiners was an oversight by board staff. They are now working to fix the issue and upload the files onto the board's website. After this and after my own personal audit of your other licensees, there are many disciplinary documents that have not been uploaded. This happened to me in 2020. They weren't uploaded, and then in December they were not uploaded. So your staff has been telling me tall tales that things do not get uploaded. And I have informed the DOJ, who works directly with the Board of Chiropractic Examiners, and my assembly person's office. Thank you.
Thank you. Is there any other public comment?
Thank you. If there were any other comments for items not on the agenda, now would be the time to either raise your hand by clicking on the hand icon or clicking on the question mark icon and typing the word comment and click send. And at this point, I do not see any further requests for public comment. Shall I close this feature?
Yes, thank you.
You're welcome.
Thank you for your comments. Future agenda items. To open this for discussion, is there future agenda items that need to be, want to be considered?
Nothing from me.
Nothing for me.
I have nothing further on this. If we can open it for public comment.
Certainly. And we've opened up the Q&A feature of WebEx to facilitate public comment, suggestion of future agenda items. If you'd like to suggest something, you can look for the question mark icon, tap that, type the word comment and click send, or raise your hand by clicking on the hand icon. And we do have one raised hand from WebEx attendee ML. I'm sending you a request to unmute, and you'll have 3 minutes. You're unmuted.
Thank you. The materials Ms. Walker just sent me were not on your website the other day. I don't know if they were only posted today, but obviously that's not enough time. So I was unable to review any of this, which is disappointing. In general, I am disappointed in Ms. Walker's lack of response to me after continually telling me she is going to respond and send me answers. I am not sure what is going on, but I am patiently waiting for Ms. Walker to respond to many important items I have brought to her attention to protect patients and consumers. I would like to see enforcement of your board employees for how long they take to respond to the public when items of importance are brought to their attention. What is the time frame for responding to emailed public comments for your meetings, as well as in general when members of the public have questions for your board staff? I am requesting timely responses to my comments and questions listed and emailed. Previous responses from the board were not given in a timely manner. My comments were also emailed to you prior to today's meeting. This is in regards to probation. When is it egregious enough for the board to put a licensee on restrictions or probations? In regard to the former licensee who committed conduct against myself and at least three others, why couldn't you have ordered probation on any or all of this person's misconduct or negligence? Why couldn't you have limited his interaction with female patients, or at the very least required a female chaperone when treating female patients? Why didn't you request he stop blood drawing and doing IVs when you knew he was doing it while falsely claiming that he was a licensed vocational nurse? Why didn't you check his public review pages, which have all of this information? Why didn't you interview more patients other than the few women who came forward? Does the board have the discretion to put a licensee on probation or request that they use a chaperone? And does the board have the right to do this, especially if multiple complaints come forward for the same reasoning? From what I can tell, the first complaint was filed November 2018, and he practiced without any restriction until the end of 2021. How are you making sure a revoked licensee isn't continuing to practice? Who monitors that? Why isn't there a checkout process to explain to the revoked licensee what they can and cannot do? And I would also like to know, once your regulations are changed, how do these revoked licensees find out what affects them? Thank you so much.
And I do not see any other requests for public comment at this time. Shall I close the Q&A feature?
Yes, thank you.
You're welcome.
Okay. Any other parting? I guess we don't want to open anything up so that we would have to open public comment again. So with that, agenda item 9, we will adjourn. I apologize. We're 26 minutes over. We'll be better next time. And I would hope that we could do a doodle pool to set up our next meeting. We probably should have done that on one of the other agenda items. Would have saved us time. But look for something perhaps in May.
I think a doodle poll is good for me too, because I can check a few different calendars, not spend a lot
I
of
thought we
time.
were booked up for a while, no?
I don't know that we're booked up. I don't know that we're booked up for enforcement, but we're booked up for our general board meetings.
I see. Okay. Yeah, you're right. Fair enough. I'll keep an eye out for the doodle poll.
Okay.
May sounds good.
All right. Thank you. Thank you, staff. Appreciate all you do. Thank you, Ms. Walker, Mr. Sweet, Dr. Paris.
Have a good day, everyone. Thank
Everybody
you.
else. Thanks
Thank
for all your
you.
input.
Have a good day.
And we are adjourned at 2:27. Thank you.